On the line now is Lis Wiehl, a legal analyst and former federal prosecutor. She's on to talk about how that trial is going. Lis, how are you?
Good morning. It's great to be with you.
It's good to be with you. Okay, look, I want to get into the final arguments in a moment.
Sure.
But first of all, the thing that has just been driving me crazy as I watch bits and pieces of this trial has been the demeanor of the judge toward the defense team. It seems at times that it really goes beyond the pale. Now, you're a former federal prosecutor. You've been in a courtroom a lot. Have you ever seen anything quite like the way the judge treats the defense team here?
This would never happen in a federal court. We'll never say never, because a federal court has just got, frankly, more of a decorum. I mean, it's just more of a lofty place than a state courtroom. But this has been pretty amazing. I'll recount to you one incident a couple of nights ago where they'd been, working late into the night, and the judge was ruling. Because what happens is when the jury is done with actually hearing the evidence, and the jury goes, they're sequestered, so they go to their hotel and they just, watch nothing and
watch reruns of Friends or something, right?
Yeah. Watch nothing and are probably very, very bored. But anyway, and then the lawyers argue about different evidentiary things and things that should come in or not come in. They argue motions. And so a couple nights ago, West, one of the defense lawyers, said, I'm really tired. It's 10 o'clock. And the judge's retort was, it's 9:56, and then kind of storms out. That was an interesting moment. I mean, I know, look.
She doesn't like West, it appears.
It does. I don't know it's personal or what, but somehow they both do not like each other, and it's very visible. Now, it's visible to us, but I don't know that it's visible to the jury, because remember, they're not privy to all this. They're not hearing all of this. Just, we are. So I haven't seen that so much in front of the jury. It's just behind the scenes with those kind of escapades that it's just really, but I've got to tell you, defense was not great either. I mean, he was whining. I'm really tired. We're working so hard. You're making us work Saturdays. Well, wear your big boy pants, man.
Right.
I mean,
Yeah.
Cowboy up, buddy.
Yeah, this is a second-degree murder trial. It's captured the attention of the entire nation. I mean, being on trial is the most exhausting thing, well, other than childbirth, that I've ever been through. I mean, it's really exhausting. But then you take a few days off afterwards, and you kind of collapse and watch Lifetime TV, and then you're good. So, that's the thing. I mean, he should not have done that. I think he provoked her. And he provoked her also because there are many times when she's made a ruling, and even from the bench, overruled, and he'll still keep fighting. And you don't do that. As a defense lawyer, well, as a prosecutor, both, you make your objection, and you make it for the record, even though he may be shot down. But once the judge has made the ruling, then you sit down and shut up about it, because you've made your record. And if you are on appeal, if you're the defense and you're on appeal, you can cite the record. Appellate court, I tried to object and look what happened. But you don't do it there in front of the judge and jury.
Lis Wiehl is our guest. She's a Fox News legal analyst, and we're talking about the Zimmerman case. Today we're going to have the defense arguments in front of the jury. Yesterday, the prosecution made their arguments, and there was one point which I thought was interesting. I'd like you to comment on it.
Okay.
This is a quick portion of the final arguments for the prosecution.
It led to the death of an innocent 17-year-old boy, because this defendant made the wrong assumption.
He's making the case of if George Zimmerman had not called 911, had not pursued this man, had not put these chain of events into motion,
right,
Trayvon Martin would not have been shot. And that is an undeniable fact. Let's face it. If George Zimmerman had just ignored Trayvon Martin would be alive today. But just because that's true, does that mean he's guilty of anything?
No, it does not negate self-defense. It really does not, because you can have all of those things and still self-defense can come into play. I mean, he started off, his first lines were, he's dead through no fault of his own. And then he went on to exactly as you just played that clip, false assumption. Not only false assumption, I'm just kind of giving you a regurgitation here, not just false assumption, but that he acted on that false assumption, and ergo, Trayvon Martin is dead. And then he went on to say, well, this wasn't just what happened at 7:16 and 55 seconds that night. This was really in play for months before, and what he was trying to get at there is Zimmerman's state of mind. Yeah. In other words, Zimmerman was a frustrated wannabe cop. This is his theory.
And I know that's their argument, but does the evidence support that argument?
And there was another game changer, though. I would have said no before yesterday, but it's more interesting now, because before yesterday, all that was on the table, really, was second-degree murder.
Yes.
Now they threw the kitchen sink out there, or spattered spaghetti on the wall to see what would stick. they even brought things like child abuse, which was ridiculous, a ridiculous reach, and the judge held and did not allow that in. But she did allow manslaughter, which is obviously lesser than second-degree murder. Carries still, a pretty hefty penalty. But now that gives the jury something, okay, if we don't want to, quote-unquote, let him go, we could find him guilty of manslaughter, which is an act that results, an illegal act that results in a death, just to sum it up briefly. That's more interesting. Now, the defense today, it's more interesting because second-degree murder, it requires a depraved mind, malice, intent, all of that. And I didn't really see that they made that case. They certainly argued that case, but there wasn't a whole lot of evidence to prove that.
I'm sorry, I didn't mean to interrupt you. Go ahead.
No, here was a guy who was trying to, be a neighborhood watch guy. There'd been a lot of things that had gone wrong in that neighborhood, and so he was out there and he was trying to defend himself and his neighbors.
Oh, but on that point, as you look at the entire case laid down by the prosecution, I have heard many legal analysts on Fox News and elsewhere who said, you know what, the case presented was a little thin. Did they overreach? Is that your assessment as well?
There's an elsewhere other than Fox News?
Yes.
Oh, there is. Okay. Oh, thanks for letting me know that. Yes, I think, my humble opinion is yes, the prosecution's case was weak. If you were listening to the prosecution's case and just kind of rolled out from under a rock and turned on the TV and were watching it, and they didn't label prosecution, you would have thought maybe sometimes, oh, that must be the defense case.
I know. Yeah.
Exactly. I mean, every witness that the prosecution had on was as good for the defense as it was for the prosecution. And don't forget, there's a little inside baseball here. Zimmerman was not charged initially by the detectives down there. So, and then there was a lot of brouhaha, and then 44 days later, he was charged. A different prosecutor was brought in. But the same detectives who were on the scene have to testify. So what are they testifying about? They're testifying for the prosecution about a decision that they made going the opposite way. You see what I'm saying? That's got to be a little bit tough.
Yeah, no, I do. I do exactly know what you mean, and that's really what's vexing, I think, all the observers here and what this jury is going to do.
Well, Lis Wiehl, it's a pleasure. Are you expecting a stronger sort of final argument out of the defense today?
Well, I think the defense has really been pretty strong all along.
I think so, too.
They've done a great job, and I'll be very curious to see what they do. So they might bring that animation back in. Mm-hmm. I think it's going to be, I expect a strong argument. But then don't forget the prosecution has one more chance.
That's right.
About 30 minutes of rebuttal.
All right. Well, listen, Lis Wiehl, it's good to have you on. Good to have your assessment of it. Appreciate it.
Anytime. You got it.
All right.